Now, I want to talk about some of the common problems lawyers encounter in cross-examination. The first one I call the runaway witness, the witness who loves to just give a speech. This is partly why you never ask these open-ended questions on cross. Sometimes the lawyer turns to the judge and says, "Please order this witness to answer the question." Well, just like when you were in the schoolyard and a bully was swinging at you and nobody wanted to stop it, the judge likes to look at a good fight as much as anybody. So don't expect the judge to do anything to help you. You ought to assume the judge is going to say, "Well, the witness can explain his answer." So instead of counting on a judge to help you, you should make sure you ask good, tight, leading questions. And if the witness still tries to give a speech in response, you simply say, "Oh, I'm sorry, maybe you didn't understand my question," and ask it again. Here's an example. You ask a witness, "Was it raining that night, sir?" The witness says, "Man, a lot was going on. Yeah, maybe it was raining, but there were gunshots, and I think they were shot by somebody your client's friends with, and then there were a bunch of other cars doing donuts up and down the street, and then your client's radio was so loud I could barely hear it." Now you could turn to the judge and say, "Objection, non-responsive. Please order the witness to answer." Your opposing attorney's going to say, "My client ought to be able to explain his answer." What do you think the judge is going to do? Maybe they should rule for you. Will they? Not very likely. A better way for you to take on an answer like that is to turn to the witness and say, "I apologize, sir. My question may not have been clear. My question was it raining that night?" If the witness finally relents and gives a straight answer, fine. You've scored your point. You've proven what you wanted to prove. You can move on. If the witness keeps giving speeches, you can try it once or twice more. Finally, though, the jury is going to understand that this is a witness who doesn't want to tell the truth. The more they argue with you when you've asked a good, simple, one-fact question, the worse the witness looks. Remember, it's not what the witness says that matters. It's whether the jury will believe them. A related problem comes when lawyers who maybe watch too much TV demand yes or no answers out of a witness. Now, very often that is the answer that you want, yes or no. But demanding it in those terms from the witness makes you sound like a bully. Imagine a lawyer saying, "Sir, I want to know right now, out of your mouth, was it raining that night, yes or no?" Your opposing attorney is going to stand up and say, "Your Honor, that's argumentative." The judge is very likely to sustain it. The other thing that can happen is the witness may say, "Well, I can't answer that with a yes or no. I need to be able to explain my answer." Most likely, the judge will back him up on that. You might ask the witness, "Was it raining that night?" The witness might say, "There was a lot going on. Maybe there was rain, there was gunshots, there was a lot of noise from radios. Man, I don't even remember." Instead of demanding a yes or no answer at that point, you just turn back to the witness and say, "So it was raining." The witness says, "I told you already there was a lot going on besides the rain." If the witness still won't answer your question, that's okay. Everyone understands that it's the witness, not you, who's being unfair. Instead of you demanding an immediate yes or no answer, the witness has made it plain to everyone on the jury that they simply will not give a straight answer.